Morning, everybody. My name is Andy Bates. I'm the Innovation Manager and Intellectual Property Lead at Business West. And a very warm welcome to you all on our autumn webinar and leadership series, Innovate 2021, Overcoming Challenges and Building for Growth, supported by Business West and Innovate UK. And this series of webinars is running through the autumn. I know it feels like summer, but I have officially been told it is autumn. And it will be covering topics from design thinking to funding and finance, to leadership, strategy, sales and marketing, as well as promoting our wider bespoke support that's available from us, and really detailing how we can add value to your company in what is very challenging business environment. Kicking off this series is a 4-part series on intellectual property, which is being delivered in partnership with our colleagues from Ingot. And I'm delighted to introduce Martin Brassel from Ingot, who will be our host for this session, which is titled IP Valuation for Fundraising, Turning Intangible Assets into Finance. As a participant of Innovate 2021 and subject to Innovate UK eligibility criteria, there is the opportunity to access our comprehensive range of intellectual property support, including services from our in-house patent and trademark attorneys, free of charge access to our online IP valuation tool, typically costed at £600. And in some cases, some of you will have access to a £2,500 subsidy towards the cost of an IP audit from an external IP attorney. And again, this is all subject to Innovate UK and Intellectual Property Office eligibility criteria. But I can discuss next steps and how to access these services at the end of this session. And before I hand you over and put you into the capable hands of Martin, I'd just like to go through a couple of housekeeping points, if that's okay. So first off is just to say that, yeah, for on-demand purposes, this webinar is being recorded, and also that your personal video turned off unless you're invited to speak by the host. We have got a Q&A function as part of Zoom, and if you'd like to ask a question, you can put that into the Q&A, and you can either do that in person or you can do that anonymously, and that is moderated. Any problems? Yeah, please just raise your hand. And indicate that you need assistance, and we can help you and support you in that. And then also we've got the chat function as well that you can use as the session runs, so that you can communicate with other attendees. And as part of that, what we'd like to do is we'd just like to run a little test with the chat at the moment, because as part of the seminar, we just need to capture who's here today, and to be able to do that so that we can do some follow on and contact you post the session. So it'd be great if we could just spend a couple of minutes just trying the chat session, and if you could please just put your name in there together with your company details, just so that we can record those as well. And Marcus is just going to take us through those 2 minutes and just make sure that we've got everything that we need. And once we've got that, we're handing you over to Martin so that we can start the session.
Yeah, they're coming in quite nicely now, Andy, so we can crack on.
Great, thanks for that. Yeah, I'll be guided by you, Marcus. You can tell me when.
Yeah, that's being populated right now, so I think we can carry on, and people can keep adding their details.
Okay, if you're happy with that, then what I'll do is, without further ado, I'd like to introduce Martin Brassel from Ingot, who's going to take us through this session. Martin, over to you, please.
Thank you very much, Andy, and good morning, everybody. I will just share my screen, which will take the merest hint of time, I hope. There we are. I hope you can all see that okay now. So we're going to have a session, the first of 4, as Andy explained, looking specifically at different things that you can do with your intellectual property, which we're going to define fairly widely, as you'll see in just a moment. This first session is going to be about finance, and we're going to look at these 5 areas. Firstly, what do we mean by IP in the context of business finance? Secondly, how IP is relevant for each of 3 key funding routes which you might be considering. So we'll look briefly at equity and debt and grants, how IP value is likely to be assessed or looked at, thought about by each of those three funding routes, and a few examples of deals that have been done, just to show you that this is all real rather than hypothetical. And then I'll finish with just a few words on the IP valuation offer available via Business West through the EEN, which Andy briefly mentioned a moment ago. So why am I talking to you today? Well, this whole area of IP and finance has been one that we've been looking at for quite a number of years, particularly since the 2013 Banking on IP report, which was done for the UK Intellectual Property Office. And that was probably the first detailed investigation of how IP can and cannot influence lending behaviour in particular. We did look at equity a bit as well. Since then, there have been a couple of reports for the Association of Chartered Certified Accountants looking at the problems around IP identification. There's a book along the way for Oxford University Press. Another report into the UK's IP valuation structure, and most recently, coming out at the beginning of last year, there was a report for the OECD, specifically around the use of intangible assets to help SMEs get finance. I'm pleased to say just at the moment, we're also engaged in a further exercise for OECD, which is effectively a case study driven update to that last paper, which should be out before the end of the year. So we know a bit about it. Here's what we think we know. The first thing to stress is that we shouldn't just be preoccupying ourselves when we're thinking about finance with the type of intellectual property assets that you probably spend most time thinking about, which is the ones that you can register. And by that I mean patents for inventions, trademarks for brands, and designs for aspects of physical appearance and styling. You also need to think about what we would describe as 5 other areas, which are all of the other intellectual property and intangible assets that you can't register, at least not in this country. So the first of those, which needs thinking about, is copyright. Copyright covers a wider range of things than you might imagine. Although it's the primary means of protecting creative works, it also covers any aspect of software code, because software is deemed to be a literary work in the eyes of the law. And it can also cover things like database designs, as well as a wealth of material that may be very important for your business that you produce. Then there's contracts. Contracts, licensing agreements would be one example of a contract that clearly adds value to your business and is relevant for your intellectual property and all of the other intangibles. Then there's 3 R words. There's resources, internal things like trade secrets that you may have. There's relationships, all the things that you know about different customers. And there's recommendations, which you can think of as being all of the awards and the permissions that your business has which help it to trade. So you might be asking, well, why such a broad range? Here are some answers to that. Registered rights are pretty important in lending because you can at least verify their existence using external databases. These are not foolproof, they're not always 100% up to date on the latest status, but they do give a lender or an investor comfort that you have something which has got your name against it. Also, technically, if you're going to use intellectual property rights in lending, these are rights which can have a security interest registered and taken against them in the form of a fixed charge. But it's important not to overstate the importance of some of these rights. I can't think of many businesses for which trademarks would be entirely useless, but I can certainly think of quite a number of different sectors where patents are probably of limited, if any, relevance and importance because they don't concern the right kind of protectable technical innovation. And similarly, design protection, although that's quite broad, isn't relevant for every business. So that's one of the reasons why you need to dig deeper. And the Gold Seam profiling tool that's on offer as part of the valuation package will help you to do that. Similarly, as Andy said, if you have an IP audit, if you're eligible for one and able to get it, that can take a more detailed look at other types of intangible assets like the ones we'll talk about now. So copyright covers these business critical assets that are important to understand because they're probably driving revenue or driving cost savings in the business. And both of those things are really important to think about when you're trying to come up with a value for your assets. Contracts are really vital because they help lenders and investors to understand how much reliance they can place on your business plans and the forecasts that you come up with. If there's no contractual basis, if there's nothing agreed in writing or even verbally agreed, then it's harder for them to have confidence that you're going to be able to deliver on your plan. So those contracts are an important intangible asset. The resources and relationship categories really show whether you've got the internal and external competencies and connections to be able also to deliver on that plan. So your internal resources might be things like the specialist know-how that you have access to within your business, and proprietary processes or technologies or algorithms even that actually run it. And these are important to make your business work. But of course, there's not much point in having a wonderfully efficient business if it has absolutely no customers, and the relationships that you have with the customers are actually what drive the revenue. So again, whether they're contractual or whether they're non-contractual, it's really important to be able to talk about them and explain how they add value to your business for a lender. And then lastly, there's this recommendations area. Recommendations, or as we sometimes call them, approvals and endorsements, are a slightly different type of intangible asset. They include things like permissions that you might require to trade, quality approvals, grant funding, R&D tax credits. All these are the things that are not necessarily unique to your business, are like other types of intangible assets, but are a really important seal of approval, if you will. So hopefully that explains why it's important to think broadly and be able to talk about your assets in detail if you expect anybody to take notice of them. And the other key point to bear in mind is that if you don't know what they are, it's going to be pretty hard for anybody else to work them out, because these intangible assets are not visible on your balance sheet or anywhere else. So let's move on now to the next point, which is intellectual property's relevance for these three main ways in which you might be seeking to obtain finance for growth, apart of course from retained profits. Retained profits are actually the way that most types of intellectual property and intangible asset investment get financed, according to research from one of our leading banks, which clearly leaves something of a missed opportunity for them. If we think first about equity, by which I mean selling shares to probably a private investor, investee companies, when you're seeking equity at that stage in your development, quite often it's rare to find very many tangible assets on which a firm value can be placed. Enterprises, when they're young, generally don't have their own property. And if they do have any kind of machinery or specialist equipment, the chances are that's been financed in other ways. So tangible assets which are used to value other types of business, more in the more sort of traditional areas of the economy, if you like, generally aren't relevant. What's important is to bear in mind that all private investors, without exception, are motivated by the potential for some kind of value realization event. Sure, there are some who are happy enough to take regular dividend payments and so forth, but mostly it's the big bang when the business actually gets sold or floated or otherwise passed on. And that's where intellectual property is so important, because if you think about it, by definition, if you manage to achieve an exit value that's over and above the general level of market expectation, it's always going to be down to the way that the business creates and uses intangible assets. And the reason I say that is because the kind of market multiples, which are, if you like, the norm in terms of exit valuations, aren't driven off intangibles. They're always driven by multiples of earnings. So if there's anything on top of that, it's not going to be down to tangible asset value. It's not going to be down to somebody coming in and thinking, oh, this is a lovely building, I'm going to pay you 2 times over the odds for it, because that simply won't happen. It's going to be down to the potential that somebody else sees in ways to exploit the intangible assets that the business has created, because innovation creates intangibles. So IP is really underpinning wherever the competitive advantage is that's essential for growth. But as I just mentioned, you can't expect every investor to be an IP expert. So you need to be equipped to show them where the value lies and explain why they should take notice of it, why it's significant. So IP inevitably features in a lot of equity discussions, and not just around What have you got protected? Do you have any patent applications? Do you have any brand protection in place? The brand protection may not be so important in the very early days of trading when there isn't a reputation as such to be protected. The detail will be in all those other categories of intangible assets that are in the innovation you've created, which you need to be able to talk about. So that's equity. Let's have a little look at debt. In terms of commercial borrowing, which is the main aspect of debt that I'm thinking of now, it's pretty common for a bank to take security over all of a business's assets, including its intellectual property. So if you read the wording of a bank debenture, the chances are it'll include IP. And the chances are that it will also mean that there is a collateral charge taken over that. What this means is that the assets are in fact at risk if the loan should default for any reason. So although traditional forms of collateral and security are more around tangible assets like property, actually intangibles are, at least in theory, within the basket of assets that a bank can take control over if things don't go to plan. The challenge is that banks have very seldom in the past attributed any real value to this intangible assets. So they're taking more collateral than they need to in order to protect themselves against the loan and not giving you any value in return. And that's because these are assets that have traditionally been placed into what I might call the too difficult bucket in order to be able to value them. And that's partly because you can't value intangible assets generally in the same way that you would tangible ones. You can't assume that there is a ready market for their resale because they behave differently, as we'll explore in a little while and through the subsequent sessions we're having. But these behaviors are changing because there's fewer and fewer companies that have got the kind of tangible assets that banks generally like to use as collateral. And also, I think it's become apparent, including through some research by the British Business Bank and the UK Intellectual Property Office, that intangible assets, and particularly intellectual property, are associated with better payment performance. So all these things are helpful in terms of trying to get the banks on side with the idea of taking these assets more seriously. And I'll give you some case studies in a moment of where this is working. I'm not going to focus too much on grants today. I think we're going to talk more about those when we talk about collaboration in a third of these sessions, and also probably touch on them with licensing in the second session in this series. But it's worth just saying a few things about grants or other forms of publicly funded support. There's a connection here because most of the grants that you can get are going to be for some form of innovation. And intangible assets always arise when innovation happens. So from any form of creative or inventive work. When you put together an application for some form of grant or support funding, quite often you will be expected to be able to demonstrate that you've got some innovative capability. Otherwise, the grant provider may have some difficulty working out whether and why you're going to be able to use the money productively. What's worth bearing in mind is that grantors, if they're providing the funding, they can sometimes obtain rights over the IP that you create with it, which is an area that requires a bit of care when applying for certain funds. There's also particular care needed when you're collaborating and you're creating IP jointly with other people, or other people are needing to use what we might term your background IP, things you've already created, in order to contribute to the joint collaborative aim. And it's also worth bearing in mind that there are certain other funding packages that are available from government agencies that may contain provisions a bit like those in some grants. So for example, if you've looked at the detail of the Innovation Continuity Loan, which sounds like a very valuable and important piece of support that's now available from Innovate UK, they will take a charge over your intellectual property, just like a bank loan would. So in the interest of time, let's move on. What I want to focus on, because it's most businesses' preference when they've been trading for a little while, is how things work with debt and how they can sometimes work with equity. So to do that, I'm going to show you a little cascade of debt funding possibilities, which I'll try and talk you through swiftly. And this is, if you like, a kind of a preference, a hierarchy of the way in which lenders might think about the importance and the value of intangible assets. Now, occasionally you come across companies which have got a big family of standards essential patents or have got a very successful music catalog, for example. The unique thing about these type of assets is that they're already independently revenue generative without the business having to do anything further with them, apart from possibly in the case of patents, maintain their level of protection. If IP has these kind of characteristics, it is suitable for something called securitization. What you can do is bundle these kind of assets together, provided they're similar in nature, and you can lend against the cash flows that you expect them to generate. Because they're being generated directly by the IP, and the IP exists, and it's not dependent on anyone else doing anything. The most famous example of this, which you might have heard of, is the Bowie bonds, when David Bowie issued a bond covering 25 of his early albums, and it was secured against the future royalty streams which were attributable to them. And it actually, although the bond's status varied a bit over its lifetime, it did ultimately pay out in full, so it was quite a successful device. But as you'll appreciate from that analogy, there's not very many artists with the same kind of track record as David Bowie. So any bank ought to be able to get its head around guaranteed income streams and expressing them as a present day value. But if that's not there very often, what's the next option? Well, the next option is if the IP is really market leading, it's associated with really strong sales, or it's something that's clearly enforceable against other people who are infringing it, then it may be possible to answer this next question in the positive. If the business failed, would there be recoverable IP value? And that's the closest that IP is going to get to the normal sense of collateral as a bank would see it. Because if this is the case, then you can underwrite a recovery value, even if it won't be the same value as the IP assets have when the business is a going concern. This doesn't happen very often either, and I'll draw on the reasons for that in a moment. Where we're at generally at the moment in the UK is this third stage, which is where the company owns assets that do clearly have some material value and they do underpin products, services or processes. So the IP may or may not have independently recoverable value or recoverable value if the business disappears, but it's clearly central to the business's activities today. And that can be used in two ways. Firstly, to enhance a cash flow lend, because it helps to understand what the value drivers are within the business, why the balance sheet looks the way it does, and also it's a mechanism by which the lender can have some additional behavioral influence by capturing assets within its security envelope, knowing what they actually are, rather than being completely ignorant of what they are. This is kind of lending that we've seen and assisted HSBC to do recently. Another possibility is you can use asset-backed finance techniques, sale and license back, which is very like a sale and lease back. And what this involves doing is taking an ownership interest over the intellectual property, but licensing it exclusively back to the business over a period of time. So the business never really loses control or use of it, it's just title that passes. And the main organisation that's been active in that is Lombard Technology Finance, which is part of the RBS group. So those are available today, or at least they would be if the banks hadn't been taken over in order to be able to distribute CBILS loans. But they are coming back again now, especially as CBILS is drawing to a close unless we suddenly find that it's been extended. If none of those apply, then we're into venture debt. So this is where you have a tech business that's got very strong equity backing, has probably already secured a number of millions of pounds or dollars in recognizable venture capital or private equity backing. The organization that's famous for doing this kind of bridge funding, it effectively is Silicon Valley Bank, but there are a number of UK and European funds that also do it. What you're doing in venture debt is you're really securing the IP value because it's an available asset that you can use to influence the behavior, not of the business, but of the investors. And it's a way for a lender to make sure that if the business doesn't meet its next milestones, can't raise its next equity round in the manner that it envisages or wants to, then it does have an opportunity to be able to secure an alternative exit. If none of those apply, then debt is probably not going to work. So if it's an IP-rich business proposition and you can't answer positively to any of those questions, it's probably because the IP that the company owns has not yet reached a point where it's got enough market traction to be able to service debt. So that's when the IP value is important to know in order to strengthen confidence for an investor or sometimes for a grant funder in the proposition that needs to be developed and taken out to the market. That's a bit of detail, but I hope that explains how the mind of the lender and the investor works in terms of trying to think about what type of IP it is that they're dealing with. I'll return to it in just a moment just to explain a bit more about valuation methods, but let's just make sure that we're all sort of up to speed with the three main ways in which value gets considered. So there are, as I say, three ways, cost being the first way that's sometimes used to think about the value of IP assets. That's one of two questions is being asked. How much would it cost to reproduce a set of assets? In other words, how much would it cost somebody else to start from scratch? Or how much would it cost to replace a set of assets, potentially with something that does the same thing but may do it in a different way? And this sort of speaks quite well to the concern that people sometimes have when dealing in IP, which is why would anybody pay more for IP than it costs them to be able to do it for themselves? And that sounds like quite an alluring set of logic, except that if you have something like patent protection in place, then it doesn't matter how much money somebody spends trying to reproduce what you've done, they can't legally use it, or you can challenge them if they try. So the problem with cost is that it sometimes doesn't value the very assets that you think are most important. Nevertheless, for valuing things like software code, which is generally capable of being reproduced, perhaps in a slightly different form, or thinking about the value of your workforce, then cost methods can be useful. Then there's market comparison. This is what's always done with commonly traded types of tangible assets. So what you're really thinking about there is, have comparable things been sold on the open market? Are they comparable enough that you can draw conclusions from the values that have been reached publicly and apply them to your own situation? Now, IP doesn't get traded independently of businesses all that often, which is why people have a tendency to think sometimes that it's illiquid. I think that's a bit of a misunderstanding, because what's really happening is that the businesses are getting bought and sold because they contain good IP that other people see is scalable and want to be able to use more widely for their own customer bases. So sometimes when we're doing valuation reports, we're looking at whether businesses owning comparable assets have been sold. Clearly, the value of a business and the value of its IP are not the same thing. One is a subset of the other, but the sales of businesses, or sometimes investment in those businesses, can give you insights into parallels that are relevant for trying to understand what the value of your own IP is. There's also databases available to tell you how much other companies are paying to license in assets that are similar. And those can be applied to particular cash flows to give you an idea of what somebody else might pay to get access to them. But generally speaking, the point of intangible assets and intellectual property is that it's unique. So sometimes finding anything that's really comparable to the assets that you've got is pretty challenging. And so for all those reasons, an awful lot of IP valuation work really ends up focusing on expected future benefits. And these are expressed in terms of income. What contribution do the assets actually make to future, or sometimes current, sales or profits? Alternatively, you can think about it, for example, if it's a process or a technology, of saying what cost savings can be attributed to these assets? How do they benefit the business? And both of those methods are perfectly legitimate to try and use. So those are the three main methods. How do they pan out across the kind of scenarios that we've described? Well, if you're lucky enough to have assets that are suitable for securitization, which I stress is quite unlikely, it's effectively the net present value of the expected future profits that's going to determine how much you can borrow. That's pretty straightforward to calculate. That's about thinking about what the current value is of those future cash flows, which you use a DCF calculation to produce. And the only thing you really have to consider is whether there's risk in those forecasts or whether the incomes are all contracted, certain, and tied up with a nice ribbon on them. Collateral is the difficult one at the moment, because the loan size really is determined by the insurable value of the assets, unless there's other forms of security being taken to round out the envelope. The main focus of a valuation exercise there has to be on the possibility that the assets will be resold if the business gets into difficulty. And that has to kind of think about two scenarios. One is a going concern where the business is still intact, but needs to refinance itself or needs to be sold in order to continue to meet its objectives, or a gone concern where the business isn't really there anymore at all, the team isn't there anymore. Can the assets still have separable value to them? Now, this is not a valuation question that's historically been considered, but the thing that's very exciting is that there are now insurers entering the market who are prepared to underwrite this form of what might be called collateral protection insurance. And one of our main focuses, following a grant from Innovate UK, which we successfully completed earlier this year, is we're building underwriting tools precisely for that application. So it's an extremely exciting space, but not one that you can really capitalize on very easily at this particular point in time. Essentially, that's where we're all trying to get to. So where are we now? As I mentioned, we've got these couple of sets of funding products which lenders are prepared to consider. Here, the loan size is mainly going to be determined by how much the business can afford to service. There's a slight difference in emphasis between the two types of product, if you like. If what we're talking about is an enhanced cash flow lend, then the valuation emphasis is mainly going to be on what is the contribution to income that the IP produces. Whereas when we're talking about a sale and license back, it's going to be focused more around what is the risk-adjusted historical investment that's been made in the IP. So that's more of a cost-based approach. The interplay between cost and income can be very interesting, but it's probably one that we'll need to leave for another day. The reason why there is a cost focus in a sale and license back is that it's very like a sale and lease back in structure. And sale and lease back you would normally use to liberate value that's sitting within a set of assets which you already own, like tangible ones. So the classic one would be to sell and lease back a property that you occupy, for example. And that's the closest parallel with this particular approach. In terms of venture debt, the loan size is probably going to be determined by what the business needs and how much has been invested so far in terms of the strength of the equity backing. So having strong assets that clearly look like they're going to ultimately drive a successful exit value that are contributing to income generation and therefore some ability to service debt are the kind of things that venture debt providers tend to look for. And then finally, in terms of thinking about how valuation works with equity funding in particular, maybe less so grants, it's pretty unlikely that most businesses seeking equity are going to have enough assets to make a cost-based approach really worthwhile. The main focus is going to be on the potential of the technology or the creative works to generate value. Investors are also quite likely to take note of market precedents. So if you can find any market precedents, it's quite useful. But being able to put a value on your IP rather than somebody else's IP, which might not be representative of your own, is going to improve the basis for being able to come up with a comparative value. Okay, so those are all of the principles. That's how the theory works. What do the deals look like in practice? Very briefly, here's a few examples. So there was one that we were involved in a short while ago for an asset management software company, pardon me, dealing with a lot of large operators in international rail transportation. The main intangible assets this business had was its software, which is essentially core to and essential to its whole business. And HSBC provided a term loan backed by a fixed and floating charge for around £700,000. And what that enabled the organisation to do was to acquire another business that with which it had been working. This was a pretty good spot in terms of the company itself, because within 6 months of loan, a company called Arcadis bought a majority stake in EAMS Group, and I believe that at that point HSBC was able to exit its loan. Another example, this time in the asset-backed lending space, is from Europa, an international transportation and logistics company, which had invested an awful lot of money in business-critical software once again. So as you'll see, in both cases, not actually patents in this instance, some brand value perhaps, but mainly in software. And this was a sale and license back. In other words, the company sold the copyright in its software to Lombard and then exclusively licensed it back, initially at a valuation of £1 million to help it get more expansion capital. And as a bit of a footnote, we know that that deal's already been refinanced, which shows the potential for this form of business finance to be used on a revolving basis. And third one, just as an example of venture debt, a patent intensive company, Touch Bionics, some of you may have heard of. They manufacture very clever prosthetic limbs. And this was working capital and a term loan, and the loan amount was rather larger, again for expansion capital, £2.5 million, with a fixed charge being taken over the patents. And that particular deal was done a little while ago by Clydesdale Bank. So to summarize, there is an increasing appreciation among all different types of financiers about how important intellectual property in its widest sense is to drive business value. So that makes it essential if you're thinking of applying for growth finance, as many businesses need to at this time to get back on track and to innovate. It's essential to understand what assets you've got, how they relate to value, and if possible, how much value that means. Because if you do know those things, you can just use them so much more constructively in all of the negotiations. And they follow a natural sequence, really. You have to know what you've got before you can value it. And you have to understand what the relationship to value is. And the same applies to the topics we'll be exploring in each of our 3 forthcoming sessions around licensing, which is next week's, collaboration the week after, and seemingly fittingly, we'll finalize the series with talking a bit about exits. So before I hand back over to Andy, just to explain the free IP valuation offer that was mentioned previously. So Ingot's best known for having tools. These are an online platform that can be used to identify and value all forms of intangible assets and intellectual property. And what this particular version that we're offering through Business West to eligible businesses is that you can get an income and a cost-based view of your IP value. The main inputs that you need to provide, apart from engaging with the tools to identify what all the assets are your historical accounts and your current set of forecasts for what you're going to be generating in the future. And this is the same system that's been used on many occasions by people like HSBC and Lombard. So if you're an existing Innovate UK supported business, there is one route. And if you're new to EEN, there's another route. And at that point, I'd probably better hand back to Andy or let him take over the screen in order to explain what those are. Unless you want to do that at the end, Andy. But that's enough from me anyway for now. That's
brilliant. Thank you very much, Martin. Yes, what we'll do is that I'll take that at the end and we'll just go into a little bit around doing a Q&A session. And so I've just, the slides have gone a bit funny. We'll do the, just do the Q&A session. We've got a few questions coming in and I'll just pick up with what those are. Just bear with me a second. Marcus, if you're there, please. Hello. because I'm in full screen mode, I can't see the questions that have come in.
Okay.
Let's have a look.
I can see one. Shall I, if I read it out, just in case other people can't see it?
Yeah.
So there's one from Paul Upton. Can cost-derived IP generally be added to the balance sheet? This is a very important question, and it's a good one to try and clear up any misunderstandings. Paul, the short answer is no, but there are some exceptions. So what you can capitalize and put on your balance sheet, which has been clarified under the latest set of small business accounting regulations called FRS 102, is you can add certain types of development cost onto your balance sheet. The issue is that you have to amortize them. So you have to write down the costs that you've attributed them over the expected useful life, which will require a bit of a conversation with your accountants. The effect of doing that is it does help to strengthen the balance sheet somewhat. It puts more assets on it. Obviously, the downside is that there's then effectively a charge to your profit and loss account each year for the amount of that historical cost that you're amortizing. So the one thing to be aware of with it is once you start down that journey and you start amortizing development cost, it's generally a good idea to keep doing it. You can't take a valuation that gives an overview of all of your intellectual property assets, even at cost, and add it onto your balance sheet, because there's only certain types of expenditure rather than asset, but certain types of expenditure that is eligible for these purposes. So the kind of thing, for example, that I mean by that, you can't capitalize any research activity because that's speculative. That's not being done in expectation of a concrete future benefit, which is one of the tests that has to be applied. But you can capitalize the development cost, for example, of software that's required to deliver a new product. So well worth having a conversation with your accountant to understand what you can do. The only other way you get intellectual assets onto the balance sheet is if you buy another business. When you acquire that business, it's now a requirement nearly always to use what's called acquisition accounting. And that requires you to place an asset on a value on all the tangible and intangible assets that you've acquired. So in that way, you can actually drag the value associated with a load more intangible assets onto your balance sheet. It's a bit like a magic trick. Suddenly all sorts of value appears that wasn't there previously. Again, worth a conversation with your accountant if you're thinking in terms of acquiring another business.
Martin, we have a question from Lloyd. I'll just allow Lloyd to ask his own question. Lloyd, if you want to go ahead and ask your question, please.
Hi, good morning, Martin. Really enjoyed the session so far. Yeah, I was just conscious that the typical bank charges cover all of the assets in the business, including the IP typically. And then if you've got someone looking at some of sort of the innovative ways you've laid out, whether they're going to bump into the fact that they've already got charges on their IP that they didn't know about, perhaps.
Yes, thank you for that question. It can be an issue. It generally isn't. The reason for that is the point that I made earlier about the fact that the original bank has seldom actually given any value for the IP. Now, the charge is still something that needs to be negotiated, and what will normally happen is that the new lender will take a look, which they can do via Companies House, to see what documentation is actually in place, and will be able to identify the previous lender and have a conversation with them. Normally what happens is if a bank, let's to put it from the business's point of view, if a business is able to go somewhere else and raise more money that actually reduces the risk of the main bank because it's bringing more cash into the business, they are usually inclined to let that charge pass and waive it. There is one other thing to be said about this. How effective can a fixed charge ever be if the assets are not correctly identified? What you will find is that in the majority of cases, even if the paperwork in the debenture says that there's a fixed charge over the company's intellectual property assets, they're not named anywhere. And there's almost certainly no charge going to have been registered at both the applicable registries that identifies the assets uniquely. So it's possible to argue that there is no priority, there is no notice mechanism to stop any other lender coming in and taking those assets over and expressly using them by applying an effective fixed charge. That's a fairly aggressive approach to take, but the fact is that if what we reduce to is thinking about a floating charge, which is also in the standard documentation, then actually a business is allowed to use assets subject to a floating charge and dispose of them in the ordinary course of business. So actually a bank that doesn't correctly and robustly identify what assets it's trying to charge is at risk of having them taken away. And this is one of the reasons why banks are starting to realize that it's really a good idea to understand what these things are. So I hope that answers your question, Lloyd. There's not a hard and fast rule. You're right in saying that there's a theoretical obstacle. In practice, it's normally not too difficult to overcome.
I can see another one that's come in, Martin. I don't know if you can see that one. There's one in from Clive Tomlinson, which says the offer of the valuation tool is welcome, but whom does it give access regarding company information?
So in terms of the way the tool works, it's used by the company. It's entered by the company executives, all the data, and it's held secure under login in the usual kind of way with username and password protection and SSL technology so that nobody else can intercept it. It's held securely on our system, and it only gets shared with anybody who the company who's completing it wants to share it with. It's probably worth saying that where we have arrangements in place with particular banks, there's a facility on the system to share the contents of the report directly with them. That's not the way this is being set up. So the only people who you would have an opportunity, if you wish to share the valuation with electronically would be your advisors. The thing you can always do though, but nobody else can do, is go onto the system and produce a PDF which you can then share with anyone you like. I hope that's answering the thrust of the question.
No, that's great. Thank you, Martin. I've just got one from myself, which is to do with the interesting thing you were talking about, the gone concern and the IP that you have when you've got a gone concern. Is there a marketplace now then for that kind of IP? I guess that traditionally it would have been in the hands if it was a company that decided it couldn't take the business itself any further, but still had the IP. Normally, maybe the administrator would be involved or the liquidators, but I didn't know if that was the case or not.
Yeah, so it does require a bit of a specialist approach. You clearly can't just put the IP onto the equivalent of eBay or Auto Trader when it's distressed. The normal mechanism that's followed is twofold. If you're really taking collateral potential in IP seriously, then before writing the loan in the first place, you'll give at least some consideration to whether there might be a market for the IP and who might buy it. Certainly, if you start to get into a distress situation from a business, thinking about it from the lender perspective, you'll then be wanting to understand in more detail who else might have an interest in taking over this IP. So what it comes back to mainly is how much traction or enforceability does the IP have in the market in the first place. It's not difficult to understand that if IP is associated with very successful products or services, then the chances are that somebody else operating in the same industry, if this IP is preventing them getting those sales, is going to be interested in taking it on. They may not want all the assets, for example, they may not want the brand anymore, but they might want the technology. Under other circumstances, what we see is that the brand can continue and have a new lease of life because the brand has not been tarnished, even if the company's got into difficulties. So there are opportunities to dispose of all sorts of different types of intangible assets. And the only thing you have to watch is it's a bespoke matchmaking exercise rather than usually a general offer for sale. Sure, I could tell you about transactions that have happened in the past. The classic one, I suppose, that lots of people know about is when Nortel Networks was broken up back in 2011, and its patent portfolio was auctioned off, and it raised $4 billion dollars, $4 billion. And it was bought by a consortium called Rockstar, which included various people. It was mainly because there was a lot of competitive bidding to try and stop Google getting its hands on it. Google then went off and bought Motorola Mobility and spent $12 billion on it. So there can be a lot of money in these things, but it's very much a case of, is there a market?
Martin, we have another question from Jeff regarding taking out IP and loans. So if I invite Jeff to ask his question. Jeff, if you want to go ahead and ask your question.
Oh, hi, can you hear me?
Yeah, we can.
Yes,
Sorry,
Jeff.
I've been struggling with my computer a little bit. Yeah, I'm just about to begin a negotiation with a large company. It's actually today, regards a license agreement for my IP. Or part of my IP. They're being a bit cloak and dagger as to what they want to look at.
Right.
Given from what you've said this morning, Martin, about how basically a loan against an IP isn't seen as a particularly bad thing, and in actual fact sounds like to some people it appears to be a good thing. Does it, in the eyes of these other firms, does a loan against your IP decrease or increase the value of your IP when it comes to looking at license agreements and the like?
I'm not sure it makes any concrete difference, Jeff, actually. There's not an enormous amount of visibility about this, and other firms wouldn't necessarily know. I guess with all of the types of arrangements that are made around financing IP, one of the things that you can say, if I take the sale and leaseback, the Lombard style arrangement, for example, if you were to sell the business with that loan in place, sorting it out is very simple. The loan just gets repaid and the IP reverts back to the original borrower or to the new acquirer. So unpicking these deals is not difficult any more than it is with other types of property. I think the way it works is, if you like, the other way round. If you are successfully licensing your IP out to another organization and getting an income stream from it, that very clearly demonstrates that there's another business out there that sees value in it. And if they see value in it and are prepared to pay value for it, that actually gives you an income stream that could potentially be securitizable at some point, but at the very least should give a lender a lot of confidence that there is real value, because that's the ultimate proof, isn't it? If somebody else is prepared to pay to access it. So I think it doesn't appear to me to be a downside from the point of view of other businesses, but it can definitely be an upside if you can demonstrate that the IP's independently got value.
Okay.
Arm Holdings has just been mentioned, yes. Well, yeah, so there are businesses obviously that exist solely on IP-backed licensing, or almost solely. I probably wouldn't characterize Arm in quite that way. But and you can turn it into extremely profitable income streams. In order to do that, you clearly need really hot IP that everybody wants.
Right, okay. And there's just an additional question from that, if you don't mind. Is that okay?
Yeah, but fine by me.
That's okay, please.
Yeah, is that if in the negotiations, I mean, should I really then be considering the licensing agreement that they have with my IP in terms of the negotiation? Because I mean, we're talking of something that's, to me, appears incredibly woolly as to what my IP as a license means to that firm, and how they would view that in terms of loans and things like that they would want to take out against that license.
Right. So I don't think they would be able to take out a loan against the license. It would, because they don't own the IP. So they wouldn't have anything available for security other than the contractual agreement to continue licensing your IP. And that wouldn't be close enough to a bank to take security over the asset. But I think it's an interesting question. If you're able to, I'm sorry it's a week late. We should have done these the other way around. But if you're able to join us again next week, we're going to talk about different types of IP licensing then.
Great stuff. Well, thanks very much. It's really interesting, and yeah, you'll see me next week.
Very good.
That's brilliant. No, thank you very much for that, Martin. And sadly, as far as the Q&A goes, we've run out of time. So I'd like to give a big virtual round of applause and a big thank you to Martin for his session. And just to say that we will be making the video available after this session, so everybody will have a chance to go back over it and have a look at it and field in any questions that they'd like to do off the back of that. As I mentioned at the start in the welcome, as participants of Innovate 2021, you do have the opportunity to access our comprehensive range of intellectual property support that will be tailored to your business needs. For those of you that are on this session that are existing Innovate UK beneficiaries and in receiving grants and services from Innovate UK, one of our innovation specialists or your innovation specialist will contact you in the next couple of days just to chat through what your needs are and how best we can support you and your business. For those of you that aren't existing UK beneficiaries or haven't received anything at the moment and would like to discuss your business needs further, then please do contact the Enterprise Europe Network. I'm just going to try and click through. There we go, yeah. And there's our details up there. And again, the Enterprise Europe Network team will be able to talk you through it and discuss how best we can support you in what your needs are. So really for me, and also what we'll do is that we will be sending an email off the back of this session as well. So you'll receive all this information and make it easy for you to contact whoever it is you need to contact. And yeah, really just says for me to say thank you for taking the time out of your very busy diaries to participate in Innovate 2021 and this first in our programme, and very much look forward to seeing you on future Innovate 2021 webinars. As Martin said, we've got another one lined up for next week, same time, when we will be looking at IP evaluation for licensing, as Martin said, and with the tagline of, yeah, making your assets work harder. And yeah, if you haven't already done so, then please do register today, either by searching for Innovate 2021 on Eventbrite or by following the link in the email that we will be sending you following this session. Thank you very much, and we really look forward to seeing you next time.